Greetings of the day, everyone. My name is Dr. Jay Shah, and I'm a recently passed out MBBS graduate. And today I'll be discussing a subject which is very close to my heart, and that has to be forensic medicine and toxicology. Now, unlike the previous sessions where I have done MCQ discussions, in these sessions I'll be only doing the past year questions from the theoretical perspective. So it won't cover any MCQs because I don't have the access to it. So I've covered three major topics, which is legal procedure, medical jurisprudence, and death and changes after death. And there are many other topics, but unfortunately, I didn't have the time to record them and upload them. Maybe in due course of time I would, but I won't be able to ensure that they come out before your exams, right? So without further ado, let's start, and I'll start with one of my favorite characters from Harry Potter and the Prisoner of Azkaban. And there's a point where Snape says to Hermione that, are you incapable of restraining yourself, or do you take pride in being an insufferable know-it-all? So many would say that it's the second time I've done it out of favor. The first time was the past year questions of the second year, and this time it's the past year questions of FMT, which is in the third year. So let's start. And some tips before I start, it's like the short answer questions and the long answer questions, right? So short answer questions are generally time tested topics, and they'll generally provide just one word. So it can be like cafe coronary syndrome, plumbism, or summons, and you'll have to elaborate on it. And in LAQs, it's a set pattern. So they'll first ask the definition, then they'll ask the classification or the types, and then they'll ask the medical legal importance or the PM findings. So that's it. And for the MCQs, I can't stress enough the importance of doing past MCQs, because it serves two purposes. First, if they're repeated, that's a bonus. And second, if there's a SAQ or an LAQ which you do not know, remembering those lines of MCQ can help you fill those answers. So that's it from my side. And so the first chapter is legal procedure. Now, many people maybe hate it or don't like it that much, but it's one of the most scoring subjects, most scoring topics in the subject. And let's start with the first one. So the first one says inquest. So define inquest, types of inquest, and write a note on any one of the following. So what is an inquest? So if a person dies, and if some other person tells the police about it, the police has to conduct something which is known as an inquest. That's the general idea of inquest. So an inquest is a legal inquiry or investigation to ascertain the circumstances and cause of death. So that's the first part, the definition. So you get 1 or 2 marks for that. So a legal inquiry or investigation to ascertain the circumstances and the cause of death. It is conducted in all cases of sudden, suspicious, and unnatural death. So what's a sudden death? Sudden death is, suppose a patient is hospitalized and within 24 hours of hospitalization, the patient dies. So that's a sudden death. Suspicious death is suspicious circumstances, like a dead body near a stream or under a bridge in the night. Unnatural death is three. You need to remember it. It's suicide, homicide, and accident. So all cases of sudden, suspicious, and unnatural deaths. 4 types of inquest: police, magistrate, coroner, and medical examiner's system. Which are prevalent in India? Only the police inquest and the magistrate inquest. Which are not there in India? Coroner's inquest and medical examiner's system of inquest. So police inquest, that's an MCQ. It's 174 CRPC, which is the most commonly performed inquest in India. It's generally performed by a sub-inspector, who's also known as the investigating officer. He goes to the site, he prepares a report, which is known as a Panchnama report or an inquest report. So 2 or more responsible persons of the society act as witnesses, and they put their stamp on, or they put their thumbprint, or they sign it. And along with the requisition copy, the inquest report is sent to the doctor to conduct the postmortem. So unless you have the inquest report, you're not supposed to ideally start the postmortem. So that's police inquest. Magistrate inquest is 176 CRPC. So 174 was police, 176 is magistrate. generally done by a district magistrate or a sub-district magistrate or an executive magistrate, is considered to be superior to police inquest, right? And which are the circumstances which will do magistrate inquest is dowry death, custodial death, death due to police firing, death in a mental asylum, and exhumation. So what's exhumation? Exhumation is digging out of a dead body. Basically, all those cases in which the police may be a suspect, or in all those cases where there is, a sense of urgency in the society. So, like dowry death is one of those. And a magistrate can conduct an inquest in all cases instead of a police inquest or in addition to a police inquest. So you need to remember that. So 174 is police, 176 is magistrate, magistrate is superior. And what's the difference? Police, magistrate, which deaths? It says it cannot hold inquest, and it says it can hold inquest in jail, police custody, police firing, dowry death. Inferior, this is superior, can order for exhumation. Exhumation is digging out of a dead body after burial, and there's no time limit for exhumation. That's again an MCQ. Coroner's inquest was performed in Kolkata and Mumbai, and it was abolished in 1999. Who is a coroner? He can be a doctor, a lawyer, or both. And what's his rank? He's equivalent to a rank of a first class magistrate. It's only a court of inquiry. It's not a court of trial. So the coroner can examine the accused. He can take the witnesses on oath. And if there's a verdict and he finds the person to be guilty, he can be sent to the metropolitan magistrate, but he cannot pronounce any punishment, right? So it's not for trial. It's only for inquiry. And open verdict, again, that's an MCQ. Open verdict is announcement of commission of crime without information regarding the accused. So if I'm not sure if you have watched the movie No One Killed Jessica, so that means Jessica was killed, but we don't know who killed her, right? So that's an open verdict. Medical examiner system, last system, it's the best in the world. And who's a medical examiner? He's a forensic pathologist. All cases of sudden, suspicious, unnatural deaths practiced in US and Japan, and it's not followed in India. So for all cases of inquest, you need to remember like 3 or 4 points. First is who conducts it, what's his rank, which one is the best, which one is better, which are the cases and in which you can conduct, is it prevalent or not, and relevant sections like 174 CRPC for police and 176 for magistrate, right? So the first question is done with, that is inquest. What are the MCQs regarding the powers of judiciary? So they'll ask an MCQ like first class judicial magistrate can prescribe a fine and an imprisonment up to dash and dash. So you need to remember it, and that's a very easy trick. I'll tell you the breakup of courts from below downwards. So first you have the second class judicial magistrate, first class judicial magistrate, chief judicial magistrate, right? Second, first, chief. So that's for judicial magistrates. Then you have at the district level, you have the sessions court. So you have assistant court of sessions, additional court of sessions, and the sessions judge, right? So second, first, and executive, assistant, additional, and sessions judge or principal judge. Then you have the Supreme Court and the High Court. So from below downwards, you need to remember 1, 3, 5, 7, right? It's all the odd numbers. So second is 1, so 1 year. First class is 3 years. Chief judicial is 5 years. My bad. You 1, 3, 7, 10. So second class is 1 year. First class is 3 years. Chief judicial is 7 years. Assistant sessions is 10 years. And for the monetary compensation, the fine, so that is 1,000 for second class and 5,000 for first class. Above that, it's unlimited fine. And again, there's a question, there's an MCQ like a death sentence which is passed by a sessions court has to be confirmed by the High Court. So that's again an MCQ. So second, first, chief, again, assistant, additional, principal, and then High Court and the Supreme Court. 1, 3, 7, 10, and 1,000 and 5,000. So that's how you can remember, because one MCQ is generally asked from it. The second question is summons. What is a summon? So summon is also known as subpoena. So sub is under, pena is penalty. So what they ask, define summons. So definition, summons is a writ compelling the attendance of the witness in a court of law at a specified time, date, place, and for a specified purpose under penalty. So, right? So it's the attendance of witness in a court of law at a specified time, date, place, for a specified purpose, and that's under penalty. So there are two types of summons, subpoena ad testificandum and subpoena ducis tecum. So ad testificandum is you need to come and testify. So that means your personal presence is mandatory. Ducis tecum is take the documents along with you. So that's the documentary part. So you need to write this subpoena types, ad testificandum and ducis tecum. So what's the procedure? You need to write it. It's issued by the judge and has the sign of the judge along with the seal of the court. It's by whom is it delivered? It's delivered by a police officer or a court officer or any other officer who is authorized to deliver it. It's served in 2 copies. You need to sign both the copies, and 1 copy is returned back as a receipt, as a proof of receipt, and the second copy is kept with you. If you cannot obey the summons, you need to convey it to the court in writing. And if you willfully disobey a summon, that is punishable under 71 and 72 CRPC. Fine is 172 IPC, which is 100 rupees for 6 months. The court can also proclaim a person as absconding, and it can also attach the property of the person who's absconding. You need not remember the CRPCs for that, but you need to know the term proclamation of person absconding and attachment of property of person absconding. So in these SAQs and LAQs, I haven't elaborated everything. I've just mentioned the main points. You need to elaborate it, but I've mentioned these points so that you don't miss upon them, right? So 172 IPC is fine. 174 and 176 were CRPC. So 172 IPC is fine of 100 rupees and a imprisonment of 6 months for disobedience of the summons. If there are 2 summons, again, it's a question asked in MCQs. You should first give priority to a criminal court. If there's a civil court and a criminal court, give priority to criminal court. If there are 2 criminal courts, give priority to the higher criminal court. So for example, a high court and a Supreme Court. So you'll give priority to the Supreme Court, summons of the Supreme Court rather than the High Court. And if it's like if you have 2 summons from the same court, like for example, 2 summons from 2 criminal cases from the High Court, one was on 1st January, other was on 10th January. Of course, you will attend the one which you received on 1st January and not the one which you received on 10th January. So the order of precedence is criminal versus civil. So criminal, higher versus lower is higher. First versus second, it's always the first one. So what's conduct money? Conduct money, again, it's a short answer question. It's the money which is paid only in civil cases. So again, there's an MCQ that is it paid in criminal cases? No, it's only paid in civil cases. Money given or paid to a witness in civil cases to meet the expenses towards attending the court. So what will it include? It will include the traveling allowance, the daily allowance, or so things like that. So in civil cases, conduct money is paid to the doctor at the time of serving summons. If the money is not paid or the doctor feels that it's insufficient, he can bring it to the notice of the judge and the court can decide accordingly regarding the money to be paid. Criminal cases, no such money is paid. And why is it so? Because each citizen is duty bound to assist the court whenever summoned. Civil cases, generally it's a dispute between 2 parties. So if one party summons you, he has to pay the traveling allowance or the dearness allowance or the daily allowance towards attending the court. But if it's a criminal case, need to attend it and no money is paid because we are duty bound to assist the court. And so conveyance charges are, however, given. And if it's a government doctor, it's given by the head of the institution, which is the dean. And if it's a private doctor, it's the court. Conduct money is generally paid only in civil cases, and conveyance charges are given by head of institute in case it's a government doctor, and private doctor, the court gives it. So that's conduct money. So we have discussed three things: types of inquest, summons, and third is conduct money. What's evidence? Define evidence, types of evidence, and write a note on any one of them. So evidence means and includes all statements which the court permits or requires to be made before it by a witness in relation to the matter of fact under inquiry. So the thing with definitions is you need to write them as it is, because the subject is forensic medicine, so it's also known as legal medicine. So you need to use some legal terms. So is known as oral evidence, and all documents which are produced for inspection of the court, so they are called as documentary evidence. So definition is pretty clear. All statement with the court permits or requires to be made by a witness in relation to matter of fact under inquiry. That means basically in relation to the case, or all documents which are produced for inspection by the court. So it's a no-brainer, right? You have two types, oral and documentary. So oral evidence and documentary evidence. Documentary evidence, what are the examples? It's certificates, medical legal reports. Medical legal reports also include a PM report, and it also includes dying declaration. So medical certificates, what certificate? You need to explain each of them, right? So simplest form of evidence is medical certificate. It's at the request of an individual, birth, death, sickness, fitness. So it has to be given by a registered medical practitioner who is registered with a state council, right? So if I am an RMP, I'm registered with Maharashtra Medical Council. So I have to put my MMC registration number and then sign it. Only then it's valid. False certificate. So issuing a false certificate is an offense. Again, it's the favorite question of your examiner in theory and in Viva as well. So issuing a false certificate, it's 197 IPC and the punishment is 7 years. It's different from perjury. Perjury is a willful telling of falsehood, so willful giving of false evidence, that's perjury. So that's 191 is definition and 193 is punishment for that. And if it involves the documentary form, that's a fraud, and that's 197. Right. So 191 is definition of perjury, willful utterance of falsehood. 193 is the punishment for perjury, and if you issue a false certificate, it's punishable under 197 IPC. MLC reports. So what's the difference between a certificate and an MLC report, medical legal case report? It's that MLC is at the request of a police or a court. So it's done in criminal cases of rape, assault, injury certificate, weapon certificate, the thing which you do in your practicals, and also includes a post-mortem report. So it generally has three parts: an introduction, examination, and opinion, so popularly called as preamble, observation, and inference. The preamble is the general details of the preliminary data, which is the date, age, things like that. Observation is what are your findings, and last is conclusion or inference, or what you make out of it. So you generally write it is suggestive of something. People generally play safe. So so if you see an injury, so you can say that injury caused by, or the weapon is supposedly, so stab wound, so it's a sharp heavy object, so suggestive of maybe a knife or a blade or a sword. So that's how you write it in the opinion, and finally you sign and then you return the exhibits. Again, I'll stress that these slides which I have prepared are not supposed to be exhaustive. They are only supposed to give you pointers. The rest of the masala you'll have to fill it in, right? So we have discussed three things: medical certificates at the request of an individual, simplest form of evidence. Then medical legal reports, what are the examples, what are the parts of it, and finally the third thing was dying declaration, but I'll mention dying declaration towards the end. What's the second type of oral evidence? What's the second type of evidence? That's oral evidence. So oral evidence, it means a statement which is made by the witness verbally in the court of law. It has to be direct. What does direct means? So if it is the evidence of a person who says that I have seen something, so it should be that person himself. If it's the evidence of a person who says he has heard something, it should be that person himself, or felt something, so that person himself. So it has to be a direct evidence. It cannot be hearsay. Oral evidence is more important and superior. And why is it so? Because it has to be proved on oath, and it can be subjected to cross-examination. So if you prove something on oath, that means if you utter falsehood, you can be tried for contempt of court, you can be tried for perjury, right? That's not the case with documentary evidence. Documentary evidence is 197, and it can be subject to cross-examination. The counsel of the opposite party can examine you. That's cross-examination. Exceptions to oral evidence. Again, it's a very famous topic which is asked. So dying declaration, you need not cross-examine a dying declaration, even if it's oral. Expert opinion, which is expressed in a treatise, for example, a book, like Modi's textbook of forensic medicine or Badale's textbook of forensic medicine. So that's an exception because it's an expert opinion which is expressed in a book. Deposition of a medical witness taken in a lower court. So for example, if you give evidence, oral evidence in a sessions court, and if the matter goes to high court, you're not called again to give your testimony again. Your evidence which is given in the sessions court is accepted as it is in the high court. Chemical examiner's report, again, it is impugned from cross-examination. Evidence given by a witness in a previous judicial proceeding, and when a certificate or a document is acceptable to both the parties, so you can accept it, right? So these are the exceptions to oral evidence, which is dying declaration, expert opinion, medical witness in lower court, chemical examiner's report, previous testimony in lower court, and acceptable to both. That's exceptions to oral evidence. What are the other types of evidence? So indirect evidence. So it can be hearsay. So X has told Y that A would murder him, right? So that's like इसने मुझे कहा कि उसने ऐसा सुना था. So that's hearsay. Circumstantial is the circumstances tell you something. For example, a weapon of the assault, of the offense, or bullet, or blood stain. So that's circumstantial evidence. Corroborative evidence is if a person writing a dying declaration survives, the evidence does not have original value, it only has corroborative value. Now, what's a dying declaration? That will be our next question. Dying declaration is a statement which is maybe verbal or written by a person as to the cause of his death or as to any circumstances of the transaction which resulted in his death. Basically, it's a dying person who is writing or telling you the circumstances which have resulted in his present condition, which may lead to death. That's dying declaration. Again, it's a very favorite MCQ. It's 32 Indian Evidence Act. By whom can it be recorded? It can be recorded by anyone, but what's the ideal procedure? A doctor should ideally call a magistrate and certify that the person who is giving a dying declaration is of sound mind. So sound mind is compos mentis. If the magistrate is unavailable, or if the doctor is unavailable, if the police is unavailable, it can be taken by anyone. No oath is taken because it's assumed that a dying person always speaks the truth. What's the procedure? It has to be in the own words of the patient, no addition, deletion, substitution, or prompting. Again, like Panchnama, you need to have 2 or more witnesses. Can be oral or written. You have to read it to him or her after recording it. If the patient becomes unconscious, you can record as much as possible and affix your signature, affix your thumb, and you have to send it in a sealed envelope to the magistrate. If the person survives, it only has a corroborative value. Like I still remember from I studied from Dr. Badale's textbook of forensic medicine, and it had some photos of dying declaration which are written on hand with ink. So it says that my mother-in-law beat me with a spoon or a ladle, and that has resulted in this injury and in my death. So that's also accepted as a dying declaration. So it can be oral or written, and you need to read it to him or her to ensure that it's correct. No additions, substitutions, deletions, or prompting. 2 witnesses, sign it and send it to the magistrate in a sealed envelope. If the person survives, it only has corroborative value. It's frequently compared and contrasted with dying deposition. So what's dying deposition? Like most good things in India, dying deposition is not followed in India. It's recorded in presence of magistrate and counsel of accused. So if you have a magistrate, that means you are taking an oath. In dying declaration, no oath. Counsel of accused means it can be cross-examined and it will have full legal value even if the person dies. So I'll just mention what's dying deposition, always recorded by magistrate, oath is administered, superior or better, statement is always recorded in presence of accused or his lawyer, and cross-examination is permitted, it retains full legal value even if the person survives, right? So in dying declaration, if the person survived, it would only have a corroborative value. But here in dying deposition, even if the person survives, it means that it retains its full legal value as a proper evidence, right? So that's dying deposition. Lastly, what's witness? So define witness, types of witnesses, and note on any one of the witness, right? So witness is a person who gives sworn testimony or evidence in the court of law in relation to matter of fact under inquiry, basically in relation to the case. So matter of fact under inquiry in common parlance is a case. So a person who gives sworn testimony or evidence in the court of law. So sworn testimony is basically oral evidence, or an evidence generally here means it implies written evidence, right? Sworn testimony or evidence in the court of law in relation to matter of facts under inquiry. So it's a deposition given an oath, that's sworn testimony. And who can be a witness? It can be any person. Any person who can understand the nature of questions which are put forward to him. That can be a witness. Two types of witness again, common witness and expert witness. What's the difference? Common witness means he can only tell what he has observed. For example, the three things which I told: seen, heard, and perceived. So if he sees something and if he tells the court, if he has heard something, tells the court, and if he has perceived something, he tells the court. So that's direct evidence. That is what a common witness can do. What can an expert witness do? An expert witness can form opinion, right? So that's the form of like, for example, I mentioned medical legal reports. So you have the inference at the bottom or the conclusion at the bottom, what the doctor feels. So that is a thing which is only accorded to a expert witness. A common witness cannot do that. So a common witness is the one who testifies or gives evidence to the facts observed, heard, or perceived by him, cannot draw inferences or form opinions. Expert witness, by virtue of his professional training, is capable of forming opinions and drawing conclusions from the facts observed by him or noticed by others. For example, if the court asks you, doctor, what do you think is this injury caused by? So you can opine or you can draw conclusion. It's an abrasion, contusion, laceration. So the type of weapon which causes it. So you can opine. So that's an expert witness, which is 45 Indian Evidence Act. A doctor, a handwriting expert, a ballistics expert, etc. They are examples of expert witnesses. And a doctor can be again both a common witness and an expert witness. Again, that's an MCQ. Can a doctor be both? Yes. A common witness when he's just telling the things which he has observed, an expert witness when he's opining or drawing conclusions. Who can be an expert witness? A doctor who is registered with a state medical council. So a registered medical practitioner registered with a state medical council. And supposedly the last question, maybe the last question, that's perjury. So what's perjury? Perjury is willful utterance of falsehood by a witness on oath, failing to tell the court what he or she believes to be true. And it's 191 is definition, 193 is punishment. Again, it's 7 years imprisonment. Hostile witness is a form of perjury. So suppose a witness says that, yes, in the initial hearings, he says that, oh, yes, I was there at the scene of crime and, it was me who saw this and saw that. And then if the person turns hostile, for example, in case of Jolly LLB, if you have watched that film, the first thing when the witness came and he said that, oh, I was there at the scene. And the second time he said that, oh, I didn't know anything about it. So that's a hostile witness. So a judge can declare a witness hostile at the request of the public prosecutor, right? And leading questions are allowed even in examination in chief. So in court procedure, there are 4 phases. It's examination in chief, cross-examination, re-examination, and court questions, right? So leading questions are only allowed in cross-examination by the opposite counsel. But if a witness is turned hostile, that means your own witness is turning hostile. That first he said something and now he's saying something else. you can ask leading questions even in examination in chief. So that's again a question. So leading questions allowed even in examination in chief. So oath, examination in chief, cross-examination, re-examination, leading questions allowed only in cross-examination. So what are leading questions? Leading questions are those which suggest the answer themselves. So you'll say, oh, do you think that this injury was caused by a sharp weapon? So the only answer you can say is yes or no. But if they ask you a question like, by what kind of weapon do you think this injury is caused? That's an open question. That's not a leading question. That's an open question. So leading questions only cross-examination, but in hostile witness or even in examination in chief. So there's a very famous scene from the movie Pink. So when Amitabh asks her, are you a virgin, Miss Aurora? हाँ या ना में जवाब दीजिए, don't shake your head. So हाँ या ना is leading questions. So leading questions, generally you'll see in many in films that the opposite counsel says that objection, that he is leading it. But leading is only allowed in examination, in cross-examination, not in examination in chief. And that's all. So I rest my case, and I hope this was helpful. 6 or 7 important questions from Inquest, summons, witness, evidence, dying declaration, dying deposition, perjury. All of them are very important. Do these well. Thank you so much. And before I forget, I'm greatly indebted to my teacher of forensic medicine, Dr. Bardale sir, Dr. Fard sir, and Dr. Nitin Ninal sir. If I have made it easy, probably it's because I have learned it from them. So I'm greatly indebted to them, and thank you for listening.